The House Committee on Families, Children, and Seniors will now come to order. Madam Clerk, will you call the roll?
Chair Young.
Present.
Representative Scopia. Present. Glanville. Here. Arbit. Edwards.
Here.
McDonald.
Present.
Wozniak.
Here.
Fox.
Present.
Johnson.
Here.
Thompson.
Here.
Madam Chair, you have 9 members present. You have a quorum.
Thank you. Now I need a motion to approve the minutes of our September 26th meeting. Representative McDonald. So moved. Okay, let's go ahead and get started. Today, we're going to take testimony on House Bill 4547 that increases the fee for marriage licenses. We will hear from the bill sponsor, Representative Will Snyder, step forward, Muskegon County Clerk Karen Bowie, and St. Joseph County Clerk Lindsley Oswald, representing the Michigan Association of County Clerks. All of you feel free to have a seat and begin when you are ready. Thank you so much for being here.
Good afternoon, and thank you, Madam Chair, Chair Young, and committee members for allowing me to testify this afternoon on House Bill 4547. This bill is pretty straightforward, so I'm going to keep my remarks relatively brief before I turn it over to the subject matter experts here. But my bill, House Bill 4547, will increase the marriage license fee to fully cover the processing cost of providing marriage licenses. The cost of providing marriage licenses is currently $20, with $15 going to the friend of the court and $5 going to the county's general fund in which the license is issued. This $20 fee was set in the 60s and has not been altered since. If the fee kept up with inflation, it would be more than $150 in today's money. That's not what we're here to ask for today, but my bill would increase the fee to $50. The $15 would continue to go to friend of the court, and $35 would go to the county's general fund, providing the county with the resources to cover the cost of creating and distributing marriage licenses. The bill also increases the additional fee paid by non-residents from $10 to $25. The bill does not alter the ability of the probate court to order the county clerk to waive the marriage license fee if the fee would result in an undue hardship. I think it's important to note that provision remains intact. It takes about 25 minutes to process the license and administer the oath, and then an additional 3 days to pick up the license and go through the signing and filing process. Over the last, I believe this is year 5 now that I have worked on this bill, I've worked very closely with the Michigan Association of County Clerks, my former county clerk, now retired, Nancy Waters, who support this change, and she's who originally brought it to our office when I had worked for Representative Sabo. This would bring thousands of dollars to county general funds across the state, relieving operating cost pressures and providing higher quality of local services. I am excited to be joined today by 2 of those clerks, including my own county clerk, Karen Bowie, from Muskegon County, and St. Joseph County Clerk, Lindsley Oswald. They will be able to further add the perspective from the clerks across our state and help answer any questions. So with that, I will turn it over to Karen.
Good afternoon, Madam Chair Young and distinguished legislators. I'm Karen Bowie, the Muskegon County Clerk, and thank you for this awesome opportunity to present to you the need to support House Bill 4547 in reference to increasing the marriage license fees for the state of Michigan. Currently, our fee is $20 for a marriage license, and $15 of that $20 is forwarded to the Circuit Court for Family Counseling Services, leaving the Vitals Records Office with $5 for each marriage license issued. This fee has not been increased since actually 1963 and is far below the Midwest average of the fees. In comparison, Indiana, the range is between $25 and $65. Ohio is $75. Minnesota is $115, along with Wisconsin being $120. It costs more to get a divorce than it does a marriage license. The process as a clerk to process a marriage license is time-consuming and costly. During the processing, at least 3 people touch this paperwork. The total time it takes to work with the customers to fill out the initial application, to go over the information for correctness, to enter the information into the system, printing the marriage license, having the county clerk sign the marriage license, filing it for the 3-day waiting period, having the customer come back to pick up the marriage license, again, ensuring that the information is correct, having the marriage license returned after the ceremony, and making certified copies, and finally forwarding it on to the state of Michigan. If there's anything that is incorrectly done on the form after the completion of the ceremony, which is about 80% of the time, due to the officiants sometimes putting things wrong in that, the staff has to recontact the couple or officiant and redo the forms. It takes a total of approximately 2 hours of staff time to finally receive $5 in payment. The cost of supplies far outweighs the proceeds. The cost of our state paper, the forms, the printers, the ink, the paper copiers, the pens, and our staff salary. From January 2022 through December 2022, our office processed 1,447 marriage licenses. To date, we've already processed 788, all to receive $5 per application. Thank you for your consideration.
Thank you for your time today. As Clerk Bowie explained, we do a lot of labor touching that paper, and the $5 we get from my office does not cover the supplies alone when you're looking at the paper and the envelopes and postage that we use. Also, we have had a formal fee study in my office, and $35 covers the labor portion. So that for us is extremely important, because while we want to keep fees low for our customers, we also want to make sure we're getting paid to provide the service. And I do have one request with the first section of the bill. There were some very recent changes where the legal age of consent is now 18 across the state of Michigan. So
I would say there is a conflict sub because of that.
Yeah.
That's already,
okay, I'm sorry.
You're fine.
That's already been noted.
That's okay.
Okay. Thank you.
Thank you so much. I was just doing some quick math based on what Clerk Bowie just shared with us. You're at 788 to date for this year. And so, right, so at the $5, that was less than 4,000, 3,940. At the $15, that gets you guys up to over 27,580. And so, and then you're saying these costs will offset the rising costs overall, right? I know that when the bill sponsor first came to me, my first question was, now how do we land on this number? This is more than double. But then we understand when we look at what's happening across the state and we look at the cost of doing business, I can kind of see where you guys got here, but if anybody would like to share some additional information on how you landed on these fees, I'd appreciate that.
yeah, I would just add, it was quite a few years ago when we were having this conversation. It was 4 or 5, and Justin Roebuck was the county clerk, still is in Ottawa County, was the chair of the legislative committee for the county clerks, and he's the one, and Karen mentioned in some of her testimony some of what other states in the Midwest are charging, and I think the lowest that she mentioned was the $50, and that's kind of how we came to this conclusion.
I have one other question real quick, because we talked about the split. Friend of court gets 15, that didn't change. Did you guys work with them? I'm just curious, did they lobby to get more out of the $50 than just to keep it at the 15 that they, I see somebody in the back going, no. I'm just curious, what did you all have to say about that?
So that is actually part of my budget that I oversee in my county, and I don't feel we need that increased for my specific county, but that doesn't mean that it's not needed elsewhere by the court system.
And I totally agree. I oversee that circuit court records too.
Very good, very good. Well, right now we have Representative Fox.
And I have 2 questions, and thank you, Rep. Snyder and ladies, for coming forward and testifying. I guess I am just wondering, I had my my legislative aide doing some research, and he said that in Indiana that there's a $2 printing fee for marriage licenses. So that's part of my question, and how do they get by with that? The other question is, aren't people in your office being paid anyway, regardless of whether they're processing marriage licenses? And then I have another question after this one.
So the $2 part, I'm surprised to hear that. I actually am on the Indiana border, and we have a lot of people who hear you can get a discount to get married to come to Michigan, and they
Okay.
cross over our state line, do a quick little marriage in St. Joseph County, and then have their actual wedding at their venue in Indiana.
Okay.
So we see that a lot because it's so expensive there, is what we've been told.
Okay.
And then, I'm sorry, your second question was?
My second question, my as part of that question was still, aren't people in your office getting paid anyway?
So actually, with our vital records staff, it's my vital records staff that's processing the marriage licenses. And one of the things that we're charged with doing is charging fees that cover the cost of running that office with the vital records. And that's why we see this the same way, because we're not trying to build up our general fund. We only want to get reimbursed for the cost that we have for the office.
Okay. No, go ahead then.
And I was going to add also the cost of our state paper. We have the specialized paper that we have to obtain, and that's very costly. So I'm looking at it more as covering the cost of the materials to even do the process.
Okay, thank you. So my second question is, and I'm putting on my Reverend hat for this question, and so I'm Reverend Joseph Fox also, and so I've got to sign a lot of that special paper and get them turned in to the clerk's office and what have you. I guess, a lot of the couples that I have been involved in their weddings, they are really pushing their finances to find a venue to rent, and they're catering, and et cetera, et cetera, et cetera, and they're striving to save money, and I often have that conversation with them. Also, I guess for me, in my county, it's Newaygo County, it's something like 40% of the kids in our county are in single-parent homes. Would it be good to once in a while have a sale on these marriage licenses to get some people married? And I'm being a little bit facetious here, okay? To, and say, hey, this week we're having marriage licenses for $10 or whatever. What can we do to encourage marriage is my bigger question. And you really don't have to answer. I'm just making a statement.
Well, I perform marriages.
Okay.
So I'm very open to making sure that the people that we work with and come in, that we provide services like an all stopped area. They can get married there in the county building and get their marriage license, and they can get prayer.
Mm-hmm. Amen. Thank you very much.
No, and I would just add that, as I said, the bill doesn't alter the probate court's ability to waive the fee if they feel there's a hardship of some kind. And then going back to your first question for that $2 fee, I think that's a printing fee.
Was it?
Yeah.
Yeah, that's what my
I don't think it's a
person found.
processing and an application.
Yeah, right. Well, thank you very much.
Thank you. Representative Edwards?
Oh, gosh, thank you very much. I just really have some simple questions. How much is the fee in Indianapolis and Ohio?
Indiana, the range I had for Indiana, was it Indiana? Was 25 to 65. It varies by area.
And you said Ohio, did you say Ohio?
is 40 to 75.
40 to 75. And the time frame that we have to apply, obtain the license before we get married is how many days?
33.
33 days. So you have 33 days before your
33
marriage to get this license, right?
Yes, ma'am.
Oh, so that would encourage individuals to get married though too, right?
Yes, ma'am.
Thank you.
All right. Well, members, do we have any other questions? Okay. Well, thank you all for your testimony. We appreciate you coming in today.
Thank you.
Thank you.
Next up, we will hear from the Office of the Children's Ombudsman. We have our director, Ryan Speedle. Hello, welcome for joining us today. Excited to hear your presentation.
Thank you very much, Madam Chair. I appreciate that. I appreciate the invitation today to speak before you, distinguished members of this committee, and Representative Wozniak. I do appreciate receiving the emails from your staff. I read those, and if I do see legislation I like to speak on, I'll come in. I appreciate that. So I'm going to be talking for about 20 minutes here, and as I understand, folks tend to fall off after about 12 minutes. I hope that my presentation is actually pretty informative and keeps you on your toes here. I'm Ryan Spidell, I'm the Children's Ombudsman, and I like to start out this presentation with a 40,000-foot viewpoint, and I'm going to work my way down into the weeds. So just a little history lesson on what an ombudsman is. It's a Swedish term. It actually was codified in Sweden's parliament in 1809. The idea back then was a nonpartisan office with broad jurisdiction and great independence. And what that was meant for back in the 1800s was a citizen's representative for the government on behalf of the citizen. They could file complaints, and the ombudsman would help them through the government processes or figuring out. So, hey, maybe my taxes aren't being paid back to me. How do I figure out how to get that done? I would call the ombudsman's office. They were started, and this is a traditional ombudsman, to cover all of government. Our office is slightly different. We are essentially over 3 areas of government. We don't cover all of government. That's why it's called the Children's Ombudsman. It's child protective services, foster care, adoption, and private placing agencies, as well as child caring institutions, which we refer to as CCIs. And there's 2 sets of national standards here in America. The Ombudsman is worldwide, so there's also worldwide standards. It's very popular in Canada, in Europe. It's fairly new in the U.S. It started in the 60s or 70s with long-term care ombudsmans at the federal level. And that was more of a hybrid model where they would actually represent the elderly individual that filed the complaint. So it wasn't more on the unbiased term because they were advocating on behalf of that client. We at the Office of Children's Ombudsman use the United States Ombudsmen's Association Standards of Practice. In fact, if you go to their website, you take a look at their model statute, it very much mirrors Michigan's statute, so much so that other states have actually adopted our statute, West Virginia being one of them most recently. The 4 key pillars of the United States Ombudsmen's Association is independence, impartiality, confidentiality, and a credible review process. So we strive to have that every day at the Office of Children's Ombudsman. Getting a little bit further down, our office was created in statute in 1994. And this is pretty interesting given the set of circumstances that we have today. I found an old presentation. The legislature in the 90s was frustrated with what was then FIA and not being able to get information about child protective service proceedings, foster care proceedings. So they needed a vehicle to do that, and that bred this office. So the Office of Children's Ombudsman was initially created to provide information to the legislature, but also to a set of individuals that are defined in the Act. I'm going to get to that in another slide. But we're housed in the Department of Technology Management and Budget, and that's done so on purpose, so we're separate from the Department of Health and Human Services. I don't answer to anybody at the Department of Health and Human Services. We are our own department. I am appointed by the governor of this state. So the mission and role of our office, in general terms, is we are trying to help progress the child welfare system and improve it if possible. And how do we do that? We do that through awareness, through advocacy, through public education, and what most folks are familiar with, which is review or investigations and recommendations that come from those investigations. But overall, the vision is to help improve Michigan's child welfare system if we can do so. So getting a little bit further down into the specific powers that the ombudsman is afforded under the Act. Advocacy. So there's an actual line in the Act that says the Children's Ombudsman can advocate with the Michigan legislature on behalf of Michigan's children. So it's broad on purpose. It's not just child welfare. I can speak to you and advocate on behalf of children about education, about gun rights, about foster care, about child protective services, about these processes. Public education is a huge piece of that. In fact, that's what I'm doing here today. We do that every day. We yield phone calls, hundreds of phone calls, probably thousands of phone calls a year. And it does run the gamut of questions from, hey, I'd like to talk to the unemployment insurance ombudsman. So we'll help them out, and we'll find that individual for them, and we'll direct them in that area. Most of our calls are what we consider information referrals. So we are giving out information about the system or about systems or about processes probably about 80% of the time. But we also conduct investigations. That's the review that you heard of. And in that, there's an area in the statute that requires me as the ombudsman to ensure compliance with the law, that being Child Protective Services, foster care, adoption, and the contracted entities that MDHHS contracts with to provide foster care and adoption services. So we want to step in mid-process here, right, as things are happening and unfolding. If we see something turning to the left and we believe that the law or just best practices should say turn to the right, we'll pick up the phone and we'll start making contact with the agency to say, hey, this is what we see. We want to shine a spotlight over here on something that we think would help maybe a little bit better. We have the fortunate nature of sitting back in armchair quarterbacking this stuff. We're not out in the world actually doing it. Another key part of my authority is pursue all necessary action, and that includes legal action to protect the safety and well-being of a child. So the ombudsman is actually allowed to file a petition to keep a child safe from their abuser if there's a certain set of circumstances that are checked off. But we have that authority. I have that authority. Ultimately, there is a report of findings and recommendations that I can produce from our review and investigations. There's 4 things that I can have a finding on as the ombudsman. A matter should be further considered by the department, meaning the Department of Health and Human Services. An administrative act or omission of an act should be modified, canceled, or corrected, i.e. I want them to change what they did or do something that they didn't do. Or reason should be given for an administrative act or omission. So, hey, I want you to explain to the ombudsman why you did or did not do what you did. And then the catch-all, any other action that the department should be considering. I think the biggest part here is that we are not a regulatory agency. I've worked for regulatory agencies at the state of Michigan. Regulatory agencies have the ability to issue fines, revoke licenses, so on and so forth. We are making recommendations. We don't live in that business model. We review it, we overview it, and we set recommendations up that we think would be successful, that would be actionable in the business model. But ultimately, that's up for policy, lawmakers, and process makers to decide. I do have a certain specific set of responsibilities in the Act, and that is the annual report production, which you should all have a copy sitting in front of you. When we produce that, it's typically in the first 3 to 4 months of the year, and we'll email it out to the entire legislature. Why? I'm required to send it to all of you. I'm also required to send it to the director of MDHHS and the governor. And the purpose of that is to advise you on where we saw our cases throughout the year and to give you any insight on system-wide issues that we see and make recommendations for improving those deficiencies. There's another aspect that is a requirement of the Act for us, and we have to review all child death cases where the child has been involved with the Department of Health and Human Services under one of those child welfare programs in the 2 years prior to the death. So what is the death alert? How do we receive them? It's required under the Act that MDHHS, our Act, the Ombudsman Act, send us notification of any child. And we're required to do either one of the following: a preliminary investigation or a full investigation. We conduct a preliminary investigation on every single complaint, every single child death that comes into our office. The first thing that we're looking for is, was this death, was it caused by child abuse and neglect? If it's a natural causes, that's not something that we tend to look at. But we want to take a look a little bit deeper because there's some things that have to have happened in the 2 years prior to the death. So was there a prior protective services investigation, an open services case, so essentially a foster care case, or an open ongoing CPS case, an assigned or rejected complaint? So even if there might have been 3 rejected complaints at centralized intake and you have a child that dies, we can go back and take a look at those rejected complaints. if the child's death occurred while in foster care, or if the child or a sibling was returned home from foster care in the 2 years prior to that child's death. And what are we doing in that death review? I'm going to break it down for you. Essentially, what we are doing is we're taking a look at the circumstances of the death, and I'm going to give you an example. We have a 4-year-old, hypothetically, that died due to acute fentanyl poisoning, so a fentanyl overdose. And then we take a look at the past 2 years. Typically, we go further than that, probably the last 4 to 10 years, depending on the history that's involved. And we'll take a look at the rejected complaints, the accepted complaints, the investigations, and we'll look at them and we'll say, how many of these involve substance abuse? And if you see, 2, 3, 4 rejected complaints, then an open protective services investigation, an open ongoing services case, mom and dad maybe got some services around substance abuse, and now we have a child that died due to an overdose of an illicit substance, that is something that we would send on to a full investigation. What happens is our preliminary investigators are in our intake unit, and they do our preliminary investigation and they make a recommendation. Those recommendations in the preliminary investigations are reviewed by at least 3 people, that being their manager, my deputy director, and then sometimes myself or the chief investigator. That's done so on purpose. We want as many eyes on that because they're all essentially making recommendations to me as the ombudsman to either open this investigation or not open it. And I say that because we switched over to the complaints here in the presentation. However, only the ombudsman can decide what an administrative act is. Only the ombudsman can decide if a complaint is going to be opened. I have delegated that authority because the act also allows me to determine how we're going to conduct investigations in our office. So my chief investigator and my deputy director do have some of that authority to either go ahead and open cases on my behalf or close them on my behalf. Prior to this role, I was the deputy director at the office since about 2019. I also was the acting ombudsman during all of COVID. And I would say estimate probably about 3,000 to 4,000 cases that I have read. As the deputy director and the chief investigator in my office, you essentially review every single complaint that comes in, every single preliminary investigation, and then every single investigation that then goes up to the ombudsman. So we have a lot of internal review, and we do that on purpose because we employ a multidisciplinary team of professionals, from Child Protective Services to adoption case managers, foster care case managers, law enforcement, folks that were in administration at CPS or CSA, Children's Services Administration. The other thing is I can initiate a complaint by myself on my own volition. One of the things that we noted when we first switched over to our new complaint management system is that roughly 25% of the children that were dying due to unsafe sleep in the first year also were born substance positive. So that's just a flag to us to say, hey, maybe we need to look at this. Is there a causation? Is there a correlation? Is this just happenstance? So that's something that we're going to take a broader look into to see, and probably partner with a lot of other data holders, such as the Department of Health and Human Services, potentially the University of Michigan. What are we really looking for in these complaints that come to us? So we get a lot of calls from frustrated individuals that are complaining about a lot of things, but they don't know law, they may not know policy, but we do, and we can listen to them and we can hear them and we can pinpoint things. So essentially, we're looking for things that are contrary to law, actions or omissions contrary to law, administrative rule, or their own policy at the Department of Health and Human Services. And so when we get those accusations from a complainant, we interview them. Our complainants are contacted within 10 days, and our intake staff actually interviews them, talks to them about their problems, and then they make an analysis based on the documents that they can see in the MySACWIS application, which is where all child welfare records are housed in Michigan. And what we're looking for is, do these accusations match up with what we see in the real world? And if they do, and they are in violation of these things, or we just see that the wrong things are occurring for the family or the child, we'll open that and forward it for a full investigation. The times that we close complaints after that preliminary investigation is when we don't see evidence matching the complaint. Those tend to be unfounded. For example, we might have a relative, say a maternal aunt or uncle, calling our office informing us that they were not assessed for foster care placement, that their niece or nephew has been pulled out of the parental home and now they're in foster care, and this aunt and uncle were not assessed. And they're concerned about that because they've made themselves known to the department. We'll start looking at it, and if we see in there that they were assessed, that they even signed off on some documents, that's not something that we would investigate. We would explain that to that individual if they chose to call and speak with us. And that's another thing I want to talk to you about, because in our law, we really want to make sure that the child and the family that are involved, that the best thing is occurring for them from what we see. So did the right thing happen, or is the right thing happening? I mentioned the complainants. So anybody can file a complaint with my office. There's a certain set of individuals that are up in front of you right now that can actually get more information about what we uncovered in our investigation. I can't give them records so far as the law says, but I can discuss with them what we found in our investigation. So if you'll notice on the list, a Michigan legislator, the parent, a child, the guardian ad litem, an appointed guardian. So these are all individuals that have some skin in the game. They have some stake in child welfare or a particular child's welfare in this game. So we can explain certain things to them that we found in our investigation. And I think this goes along the lines with advocating on behalf of Michigan's children. So back to that first slide where we talked about the creation of this office in the 90s and providing information to the legislature. I can do that. So I'm going to talk a little bit about confidentiality. So not only is it a national standard of ombudsman's offices, it's a deeply ingrained in the act that created this office. So specifically, our records, I should say, are exempt from FOIA. They're exempt from court order and subpoena. And that's done so on purpose because we want to protect the people that make complaints to our office. We also want to protect the witnesses that speak to us. Mind you, we are talking to department employees that sometimes often feel that if they discuss certain things with their agency, with their supervisor, certain things might happen. Whereas if the message comes from me as the ombudsman, that's a little bit different. So when you read our published reports, we really try and scrub the identity of who provided us the information, but still get that information out in a way that you can absorb it and use it. The Act actually says that all of our complainants are confidential. I can only release the name of a complainant if I get permission from that complainant. Internally, we've devised a process where they have to sign off on that. You can imagine sometimes we do have to have that if we're going to advocate on behalf of a potential foster parent because we believe that's in the best interest of the child. We would have to identify that person to the department, but we clear that with the complainant first. I'm almost at the end here, so bear with me. So I'm just going to talk a little bit about our day-to-day processes, most of which I already touched on. We do quite a bit of public education. You know, when I am asked what I do for a living, I immediately have to follow that up with an explanation of what an ombudsman is and what it is we do. But that is really pales in comparison to what my staff do. They yield, anywhere from 1,300 to 1,500 calls or emails or complaint intakes a year. They go through all of those. They speak to all of those individuals, and these calls tend to take 30 to 60 minutes. Most of these people want to be heard, and that's really what we're here for. We conduct our preliminary investigations. So that same unit that does public education does our intake and our preliminary investigations. As I said before, they conduct that. They make their recommendation to their supervisor and to me. That preliminary investigation goes up the chain of command. If an investigation is open, it moves over to our investigative unit. Right now, we have 5 investigators. We have one that's vacant, so we technically only have 4. We're actually short 2 people. We're small, but we're quite mighty. There's a total of 13 FTEs in my office. We only have 11 positions filled. That does not include the appointed position. A big piece of what we do in trying to ensure compliance with the law and stepping in midstream is essentially mediating a case or a complaint. That's like at the heart of what an ombudsman does. And it's unfair to say we're impartial because we're on the side of the child that's involved. You know, so often parents or individuals that are involved in the child welfare system will call us and say, I need your help. And we understand that they do. However, we're there on behalf of the children that are involved in this because they often don't have voices, they don't have faces. In the administrative processes, sometimes they're forgotten about. And we're there because we can get down into the weeds and give them that voice. So that's a big part, and there's actually a set of bills. There's a House bill and a matching bill in the Senate that I believe they're all enrolled as part of the juvenile justice package, and it actually puts mediation into our act and codifies it, which is great. We've talked about findings and recommendations. As of October 2020, we can finally publish our reports of findings and recommendations. They read a little bit like a CIA document because I have to redact identifying information, but you can understand what is going on. We try and give a picture of the things that we learned in our investigation so our findings make sense, and then the recommendations match those findings and the facts that you saw before you. And then, of course, we have our annual report, our released reports. Our annual report takes anywhere from 3 to 4 months to develop. It's a whole team process. In fact, we're starting that right now for 2023. Key takeaways. So I think we are here to inform, to advocate, to review, make recommendations, and to educate the public. Confidentiality is a big part of what we do. Our investigations are extremely confidential. That is a very powerful tool to take into an interview. Our investigators typically interview anywhere from 3 to 20 people per investigation, and it's a very big advantage to say to a person, look, your supervisor will not know what you're going to say to me. Your director will not know what you're going to say to me. Only I and the ombudsman will, unless you tell them. You know, so this encourages, I think, people coming to us and explaining situations that maybe they might otherwise not feel empowered to do. The results of those investigations, so if I have a finding based on those 4 things that I described earlier, I will publish that report of findings and recommendations. However, if you fall in one of the Section 5 complainants and you're a complainant of the case, we offer up in our closing letter, so I'm not doing a finding, we're just closing this investigation. Sometimes we do what's called an informal remedy. So we've worked with the department and mediated a remedy. Our complainants really won't know that because they don't get a report. They get a letter from us that says the case is closed. That's all I'm allowed to give them as a record is concerned. But we invite those Section 5 complainants to schedule an appointment with me to talk to me about the investigation and what I found. And I will meet with them in person. A large percentage of them are done on Teams. I'll actually identify them through their driver's license. I have to make sure I'm talking to who I'm talking to is the correct person. And then working with MDHHS. This is a big part of it. So I have done a lot in the last 3 to 4 years in just going around the state and talking to various MDHHS offices to explain what we do. We are not the overseer or the press has used many terms to describe our office, none of which I believe are accurate. We, I believe, are a partner in helping shape government to move forward in child welfare to make it better in Michigan. That involves having MDHHS at the table in our investigations, in our interviews, and also we ask staff at the department, at all of these places when we interview, what do you think would help? The 13 of us don't have all of the answers, but I think when we have a combined effort, we can get to some good places. So that boils down to cooperation. And ultimately, I think what our cases can do is spur some open dialogue amongst all of these partners that have a stake in child welfare. I know I rattled through that pretty quickly. This is my contact information, my email address, our website. That's also our phone number. You can file a complaint with our office. You can forward constituents to our office. We help. We like to help. That's what we do. So with that, I would like to take any questions you may have about what it is we do and how we operate.
Well, thank you so much for that presentation. That was a mouthful, and no, I didn't get bored. I was like, this is so much. So I do have a couple of questions before we go to some of the members. I'm just curious, where do the majority of your complaints actually come from, would you say?
Are you speaking like geographically?
No, I'm speaking like categorically. Is it, when this list that you showed us of that slide, all the people, the legislature, the biological parent, you showed us that slide and you said, it says, so you're a complainant.
Yep.
And I'm just curious of those, is there a way to know, like,
There
how
is.
many, right?
Yes, there is. I don't have that statistic in front of
Okay.
me, but we invested in a records management system in 2019 that actually started in 2020, and we have a very robust application that sits on that to pull data. We just have not really fully learned the aspect of that. But, Madam Chair, I can actually get you those statistics if you would like me to follow up with them.
Okay, yeah, that's fine. And then a quick follow-up, or really just kind of a separate question. So one of your slides talked about one of your main goals is public education, which is why we asked you to come here. And I'm always telling people back in the district, there's thrilling government television you can watch. You can always watch our hearings at your leisure, but to get this type of information. And so I'm curious to know what your outreach, how do you all do public outreach so that people can know that they can call on you, that you are a resource to them?
I really appreciate that question. Essentially, we have never had a budget for that. And we have never really had the bandwidth for that. Our public education intake unit, unfortunately, is solely reactive. I would like to, the goal of mine since I've been here is to move into that space. We're more proactive. And we go out and make presentations to the public. I don't know where that would look like. But for example, if these two bills become law to change the name of our office and increase our authority, I'm going to have to go around this state and start talking to those individuals that own and operate juvenile detention facilities to educate them on the new act, the new law, the new authority of that individual that holds that seat, so they're aware of it. But that is constantly on our radar. Right now, we are short 2 people, unfortunately, and one of those actually ends up in the public education and intake unit, and they are sacked with intakes. And that's pretty much the base of it, the brass tacks of it.
Okay, well, we'll see what we can do to help you with that.
Thank you, Madam Chair.
Representative Thompson.
Thank you, Madam Chair. Thank you so much for your presentation. Again, it was very interesting, and I think we're all very interested in hearing what you have to say. I believe that all of us serve on this policy committee for a special purpose. A lot of that has to do with our families, our children, and our seniors. I was able to pull up probably the most recent report that you had provided on your website. I did look it up, and it says that this is a report, findings, and recommendations. So this involved the death of a minor child. It looks like you sent DHS some recommendations in June of 2023. I'm assuming that you send the recommendations to DHHS and then give them the ability to respond to your recommendations on what their interventions are going to look like, and then you would publicly then share with the public what you told them that they needed to do, because it looks like their letter came to you in May saying this is what we're going to do to put interventions in place that we can fix this, and then you published it in June. Does that sound about right?
That's absolutely
Yeah, that's
correct.
kind of what I figured. You want to give them the opportunity. So the thing that I felt most disheartened about when I'm reading through this, and I know that you had stated that you are not overseeing DHS. You have no ability to hold them to accountable if there are any failures or any children that slip and fall through the cracks. So when I'm reading through it, and when they tell you that they're going to do X, Y, and Z, you don't have the ability to ensure that they did X, Y, and Z. You're just making a broad recommendation, but I still don't understand who makes it accountable for them to actually enact the things that you recommend for them to do. So when I'm reading through it, you are telling them, for instance here, speaking directly with a CPS worker, the CPS worker needs to speak with an examining physician immediately regarding abuse to a child, And then MDS is saying, we respect that, but ideally, medical professionals aren't available. Another case, you said CPS caseworkers and their supervisors need to be documenting in a narrative format, and I'm assuming to educate people on a narrative format, it's not like you're filling out a form and you're checking. This is my understanding. So if you were doing a subjective form, you might be able to click, appears to have this, or they need this, or how do you feel about this, and you're just checking in the blanks on how the parent or the child responds. But a narrative form is more telling a story about what's going on. This
Correct.
is the situation. This was what was said. This
Much
is what
like
I
what
observed.
you're reading right now, yes.
Yeah, so you say this is what you need to be doing. This is our recommendation to you. And then they're saying, well, that's all nice and good, but we'll consider that. So, and I go on and on and on, and everything that you recommended for them to do, they have a response that, well, we'll look into it.
Representative,
Yes.
thank you. We're following. I want to give him an opportunity
Yeah,
to respond.
sorry,
That was
sorry.
it. I just want to give him the opportunity to respond.
Yes. So I heard a couple things there. So I forgot to talk about the process part. So the act actually requires me, if I'm going to criticize actually any entity, I have to provide the report to them first. They get 60 days to respond. That 60 days is actually in a MOU that I have signed with Director Hertel at MDHHS. So after that 60 days has gone by, they'll send a response to me. In the act, I have 30 days from case closure then to redact the report and publish it. So what we do is we put it on our website, which is where you found it. And you're correct. That is often how we get responses from the Department of Health and Human Services. Again, this is about educating the public. You can see how our case came to that conclusion. You can see the response from the Department of Health and Human Services. I think my next statement would be, that's probably a really good question for the Department of Health and Human Services to answer.
And that's what I wasn't trying to grow you, because
I
my
understand
point was
that,
coming
yes.
out that you're in a position that you should be making these recommendations based on being an outside entity.
Correct.
And it doesn't sound like they're seriously taking your recommendations. So who is ultimately, who
This
do we
is what
turn
we'll
to?
do,
Is
though,
this-
Representative.
Is this us? Is it the legislature that holds them accountable?
Well, the department has a director who's been appointed by the governor. So there is a process in place. But these are legitimate questions. I don't have a problem with the questions. They're legitimate. But what we have to do is bring the department to come and to answer those questions. Those aren't the questions that you can answer, because they lie in the realm of Department of Health and Human Services. So we'll work on getting them in here to actually provide us with some additional
That would
information
be wonderful, because I
around
think
this.
many of
Absolutely.
us sitting here are very, very tired of hearing about this happening with children across the state of Michigan.
Thank you so much.
Thank you.
Representative Glanville.
Yes, thank you. Thank you, Madam Chair, and thank you for being here today. I did not know about the Office of the Ombudsman's Office for Children, so thank you.
You are not alone.
And just as a quick follow-up to my colleague, and then I'll answer my question, I'm looking on to addendum A in the report that you gave us, and I'm seeing here that, and again, maybe I didn't see what she was looking at on the website, but I am seeing here that there are responses from MDHHS to your recommendations. So it seems like it's, again, I don't know what the follow-through is, and I look forward to hearing maybe more from MDHHS, but I do see where they are responding to your recommendations. In some cases, they agree, and they say they're going to do certain things. Again, where that additional follow-up comes from, I don't know, but I don't feel like it's a complete void there, so I appreciate having that included in the report. And then my question had to do with the confidentiality piece, which I understand the power of that and those things, but and I admit I was listening, but I was also kind of flipping through the report, so maybe I missed it. But to what extent are you involved in like legal case? I mean, you said that your reports cannot, or you can't, that you're protected from court orders and subpoenas. So how do your reports and the investigations, what you uncover in your investigations, how do those get into the legal system in some form?
So I don't know that they're actually meant to.
Okay.
One of the portions of the act actually requires me, if there's an open criminal investigation, to get a release from the prosecutor or attorney general, if the attorney general is handling the criminal prosecution, that says that the release of my report will not interfere with the criminal investigation or the criminal case. As you can imagine, we would be interviewing witnesses of that case and potentially putting their statements into a report. They may not be identified, but that report goes to the department where these witnesses are employed. So that is protective of the criminal justice system and the criminal justice case. I believe that's in there on purpose. You know, if you're thinking maybe along the lines of also like an administrative hearing, maybe from an HR action, everything that's in our report is information that the department can obtain if they do their own separate investigation. We sort of lay out the evidence that we have and the breadcrumbs for them. They can find this stuff themselves if they choose to look.
Okay. And just to make sure I'm understanding, then your office only deals with children in the welfare system?
Yes.
Child welfare system?
So specifically our jurisdiction or authority is over child protective services, foster care, adoption, and then some juvenile justice right now. They have to be dual wards and given wardship to the state to care for. And then also private placing agencies and CCIs or child caring institutions. So yes, it's very much child welfare.
So abuse and neglect between a biological parent and child would not be covered by your office?
So the actual abuse investigation is not. We do the administrative investigation of the investigation and the services provided.
Okay.
Yes.
Okay.
Sorry I wasn't more clear on that.
No, I was just getting confused because I kept seeing,
It's
the abuse
confusing.
and neglect piece, and I was like, isn't that CP?
Yes.
Isn't there somebody else involved here?
Yes.
So, okay, that's helpful. Thank you.
You're welcome.
So for clarity for me, so you basically, if there was a complaint regarding CPS's investigation, you would come in and investigate.
Correct.
All
Yes,
right.
that's correct.
Very good. That's what I thought you were getting at. Okay, Representative Wozniak, Minority Vice Chair Wozniak.
Thank you, Madam Chair. I'll be quick.
Yes.
Thank you for your report. Very nicely done.
You're welcome.
You have a figure on page 11 in that yearly. It's a pie chart. Do you know anything about that one?
Yeah, I do.
Okay, I was wondering why only 1% of the cases have been successfully mediated.
So in 2022, we actually started tracking that in our case system. We actually had not tracked that before. And to make that change, we had to go back to the vendor and ask them to do coding and fork the application so we could actually track that. So that's not a full year. It also relies on human input to make sure that they click the box off that this is successfully mediated. One of the issues we found is that's actually at the front of our case, and it goes essentially from left to right in our case management system. So if you're all the way at the end and you're the investigator and you've spent 8 months with this case, but you've mediated it successfully, you may forget to go back and check off that mark. So there's a lot of different things that go into that answer. It's also something that we hadn't tried before historically, probably up until 2021, 2022. Previously, our office was essentially a desk audit office. We would sit and we would review paperwork, and we would issue findings based solely on policy violations. If you read the act, nowhere in there does it say anything about a policy violation or policy deviance that we're supposed to point that out. I don't have a time machine to travel back in time and stop that policy deviation or vergence, right? So we're trying to do that in real time, which is the mediation. But part of that is actually getting the Department of Health and Human Services to listen to us. That takes relationship building.
It sure does.
That's taken a long time. Yeah, we're essentially getting that ramped up. We even had discussions about this morning at our staff meeting. It's still very new to our office.
In your booklet also too, it mentioned that you're using MySACWIS. Are you still using MySACWIS?
Yes, we have access to SACWIS. We have read-only access to all of it. So we have essentially access to confidential case records. If they're marked confidential, we have access to all of it that we should have access to.
And you follow the Auditor General's report on CPS?
Yes, I was aware of it, yes.
Okay, the couple thousand felons we have in the system and the 3,000 missing kids we still have?
I am not aware of what you're talking about.
Okay, well, you and I can talk about that.
That sounds like a good plan.
Thank you, Deputy
Thank
Director.
Yeah, we'll all get some information on that. How about that? Representative Fox.
Thank you very much. I'll be very quick, and these are both stat questions.
Yeah.
My number one question is, are you beyond, some of your stats that you're keeping in the book here, are you keeping track of socioeconomic status of kids or urban, rural, or others of those type of stats? And do you find that type of stuff helpful in what you do?
No, but that's a very good suggestion for us to do. The ombudsman at the time, when we first entered in the contract with this vendor, that individual did not want to take race into account. So we don't even track that. Okay. And we're learning, as people are asking for stuff, things that we could potentially put in there. And actually, one of the things that we have a work project set aside for, so money set aside for from you all, is to upgrade our system. And that was based off of one of our audits in 2018. So our new system with the same vendor, we have the ability to configure these things much faster, so we don't have to rely on the vendor to do it. Mm-hmm. We can have somebody in our house say, look, we want to start including in household income in this. So we can actually pull those fields over, define them ourselves, so we can start capturing that information. We do have it broken down by the Department of Health and Human Services business centers, the 6 business centers, service centers, the BSCs, then by county, and then by district or county office. So we can do that from like the organizational side. The other side of it, we just haven't enhanced it to that point yet.
And the another quick question is, what is the difference between a primary death alert and a secondary death alert?
That's an amazing question. I'm so glad you asked, because we have invested so much time in our secondary death alert system. So the office, we had a material finding in 2018 from the Auditor General, and part of that material finding was MDHHS missed sending us about 200 deaths that they should have notified us, and that was over the course of like a 2 or 3 year period from 16 to 18. So the material finding was that we have to do more to find this information ourselves. Even though the law says they have to send it to us, we agreed with that. So we worked over the next couple of years. COVID really threw a wrench in that and paused it, because all of the IT resources were pulled to respond to that. But once we started going again, that's when we developed our secondary death alert system. So the primary alert system is what you saw there. It's SACWIS. My SACWIS sends a host of individuals an email when a case manager goes in and checks off that a child is now dead. So that automatically sends out emails. We're recipients of those emails. Every single person in my staff, because of how they're identified in SACWIS, gets that email. The secondary part of that is a programming that we set up. So it takes all the children that died yesterday that Vital Records has been made aware of. So it's the same department, but it's separate because it's on the human services side, the health services side, not so much on the human services side, but it's just computers talking to computers. So Vital Records will say, here are the 10 kids that died yesterday, and they'll take a look at SACWIS, and the computer system will say, do these kids, are they in SACWIS, and then do any of them meet that criteria? So was there an open CPS case within 2 years prior to the death? And if so, we get a batch list that comes back to us with those names, in a sense, so we don't miss a name of a child that we should be reviewing the case of. So it's like a redundancy to the primary alert system.
So there's not repeat going on there in those numbers. It's
correct.
You find these,
yes.
Another way. Okay, good. Thank you very much.
Okay.
You're welcome.
Thank you. Representative Kofia.
Thank you, Madam Chair, and thank you very much for coming in to speak to us today. I really appreciate the annual report. I've been looking through the report for 2022 and the recommendations broadly that the Ombudsman is giving from page 22 to 25, but specifically I honed in on the ones that are for us, for the legislature from last year. And you've mentioned a few things that made it into the juvenile justice package potentially, but just could you very briefly speak to, you've got 3 recommendations here for the legislature having to do with amending current law around removal of children from parental custody, Another one is around, let me see, making sure all mandated reporters actually receive training in child abuse and neglect detection regularly. And then the third one, it looks like, is expanding the amount of time for mental health records being turned over to CPS relative to the 30-day investigation they have. So I'm curious, and perhaps Madam Chair or other members of this committee know, that was in 2022. Do we have current introduced legislation that speaks to these?
No. So in last session, the mental health records piece was introduced. However, I don't know that it ever actually received a committee hearing.
So that's the third recommendation here, the mental health.
Yes, and the other two, not to my knowledge, no.
Okay, and I guess that's also a question for Madam Chair, so maybe we can follow up and chat about that. Thank you very much.
You're welcome. Thank you.
To you, we know that there's a need to help with public outreach and getting a message out about what it is, the good work that you all do. But in addition, we will look at these recommendations and we will take it from there. That's all the time we have. But members, by all means, be certain to follow up with the director after today's testimony. And again, thank you so much for being here and for the work that you do, looking out our most valued possessions, our children.
Yes. Thank you very much, Madam Chair. I appreciate it.
All right. Well, with that, seeing that there are no absent members, the Committee on Family, Children, and Seniors will now stand adjourned.